Dear students, welcome back to your education channel Learn and Educate, where we were learning Code of Civil Procedure 1908 under Section 151, Savings of Inherent Powers of Court. Nothing in this code shall be deemed to limit or otherwise affect the inherent powers of the court to make such orders as may be necessary for the ends of the justice or to prevent abuse of the process of the court. That nothing as the power conferred in the code shall be deemed nothing to limit or otherwise affect the inherent powers of the court, that the code of civil procedure code shall not eh, limit the inherent powers of the court as to make orders, to pass a decree, to pass an order which are necessary for the ends of the justice and to prevent the abuse of the process of the court. Section 152 states about amendments of judgments, decrees, or orders, where due to any clerical or arithmetic mistakes in judgments, decree, or orders or errors arising from any accidental slip or omissions that may at any time shall be corrected by the court either of its own motion or an application made of any of the parties. When a mistake has been committed which is clerical in nature, arithmetical mistake in the judgments, decree, or orders passed by the court, or any errors arising from any accidental slip or omissions which at any time shall be corrected by the court, either on its own motion or on an application made to it by the other parties. Section 153. Power General power to amend. The court may at any time, the court has at any time, on such terms as to the cost or otherwise as it may think fit, shall amend any defect or error in any proceedings or in any suit, and all the necessary amendments shall be made for the purpose of determining the real questions or issue raised by or depending on such proceedings. When any real issue has arisen, determining the real questions on an issue raised by or depending upon the proceedings, then as the court may think fit at any time on such terms and conditions, and as to the cost or otherwise it may think fit, amend any defect, amends any error in the proceeding in a suit, and all the necessary amendments shall be made for the purpose of determining the real questions or raised or depending upon the proceedings. Section 153A, where power to amend decree or orders which appeal is where appeal is summarily dismissed, where this appeal is dismissed summarily, where as per section 152 as per section 152, the amendments of judgments or decree or orders in respect of any clerical error or any arithmetical error occurred on account of any accidental slip or omissions of the facts, then it shall on its suo motu own motion or an application made by the parties shall have the power to amend the judgments. In that manner, when an appellate court dismisses an appeal under Rule 11 of Order 41, the power of the court to amend under Section 152, the decree or the order appeals against may be exercised by the court which had passed the decree or order in the first instance, notwithstanding that the dismissal of the appeal has the effect of confirming the decree or the order, as the case may be, shall passed by the court at the first instance. Here, the power to, as per Rule 11 of Order 41 is appeal from original decrees. There, or Rule 11 is power to dismiss appeals without sending notice to lower court. Here the appellate court shall, after fixing a day for hearing the appellate or his pleader and hearing him accordingly, if it appears as on the day, may dismiss the appeal. Second, if on the day fixed or any other day to which the hearing may be adjourned, the appellant does not appear when the appeal is called on for hearing, the court may make an order that appeal is dismissed. The court will make an order for the dismissal of the appeal. The dismissal of an appeal under this rule shall be notified to the court from whose the decree the appeal is proper. The dismissal of the appeal shall be notified to the court from where the decree appeal is preferred. And when an appellate court, not being the high court, dismisses an appeal under sub rule 1, shall deliver a judgment recording in its brief grounds for doing so, and decree shall be drawn upon in accordance with the judgments at the first instance. Section 153b, it states about place of trial to be deemed to open court. The place in which any civil court is held for the purpose of any trying, the place in which any civil court is held for the purpose of trying any suit shall be deemed to be an open court to which the public generally may have access to so far as the same court can conveniently contain them, provided that the presiding judge may, if he thinks fit, order at any stage of any inquiry or into trial of any particular case the public generally or a particular person shall not have access to or be remain in the room or building used by the court. Thank you for watching.